In this video, we're talking about how to protect your home from the Medicaid estate recovery process in Georgia. Picture this, you spend your entire life paying off your house and you plan on leaving it to your kids. But when you pass away, Medicaid comes to your family and forces them to sell your home to pay them back for the assistance that they gave you. This is what the Medicaid estate recovery process is in Georgia, and your family has the potential to lose their inheritance to paying back Medicaid. The good news is that there are ways to stop this from happening. So let's talk about how it works, some of the risk involved, and what you can do today to protect your family and their inheritance. So what is Medicaid estate recovery? This is a simplified version. If Medicaid pays for your care after 55 years old for things like nursing home care, then they have the right to come back and get paid back for the assistance that they gave you. What they will do is when you pass away and your assets are going through the probate process, they will file a claim with the probate courts, and your family will have to sell off assets inside of your estate to pay off the debts that you owe back to Medicaid. So your estate includes everything that you owned when you pass away, including your house. The state's claim is basically a bill for the assistance that they gave you during that period of time. The Medicaid look-back period is 5 years before you applied for Medicaid. So any assets that were transferred during that 5-year period, your estate will be penalized for that. Some exemptions are going to be that the state will not touch your home if your spouse is still living in it, if you have a child underneath 21 years old, or if you have a disabled or blind child living in the home. In terms of estate size, the Medicaid will not come after an estate that's $25,000 or less, but most people are above that in terms of the size of their estate. So the bottom line is that Medicaid will allow you to keep your home while you're alive, but when you pass away, they can force your family to sell your home to pay them back for the assistance that they gave you. That is unless you've taken the proper steps to protect your home from the Medicaid recovery process. So let's talk about how the Georgia Medicaid program evaluates your home while you're alive. During your lifetime, your home usually doesn't count against you for the qualifications for the Medicaid program. This is going to be true if you live in it, your spouse lives in it, a disabled child or a blind child lives in it, or the equity in that home is less than $730,000 for the current year of 2025. That number could change as the years progress. But your other assets do count against you. If you are single, you can only have $2,000 of assets. If you are married, you can have up to roughly $158,000 in assets. Once you pass away, the protections that you have while alive do fall away unless you have a spouse living in that property or a child that is disabled, blind, or a minor. When the protections do fall away upon your passing, that's when the state steps in and requires your family to pay them back out of your estate. So what happens if you don't plan ahead for Medicaid? 3 big things are going to happen. The first one is that Medicaid can force your family to sell your home during the probate process. The second is that anything above $25,000 in assets is at risk. And if you transfer the ownership of your home within 5 years of applying for Medicaid, there's going to be a penalty period where they will not give you the assistance. Let's put some numbers to this. Let's say you have a home that has $300,000 of equity. You transfer it to your kids 2 years before you apply for the Medicaid process. They will look at it as if you gave away that $300,000 to avoid paying for your care. They will divide that $300,000 that you gave away by the average cost of nursing home care in 2025, which is roughly $11,000, which equates to about a 28-month penalty period where they will not give you assistance, which basically means that Medicaid is going to make you pay for your own care for 28 more months before they will step in and start giving you assistance. So let's talk about a quick guide to picking the right strategy for you. Obviously, you're going to need to talk to an attorney to make sure that the assets and the goals that you have are aligned with the estate plan that you are setting up. These are just general things that you can do. If you're married and your spouse is healthy, you can transfer the property to them. If you have 5 years before you need to apply for Medicaid assistance, you can put the assets inside of a Medicaid Asset Protection Trust. If you have less than 5 years, but you don't have an immediate need for the care, you can put your assets inside of a Ladybird deed. If you have a child that is disabled or under 21 years old, the property is already protected. Then if you are single with no protections, you can put the house inside of a Medicaid Asset Protection Trust to protect it. But what are your main options in Georgia? Let's talk about the tools that your family can actually use to protect your property from Medicaid. The first one is going to be a Medicaid Asset Protection Trust. This will be an irrevocable trust that you put your house inside of. It will fully separate that house from you as an individual, giving it asset protection from creditors, which in this case would be Medicaid. If you are going to try to use this strategy, you have to put the house inside the irrevocable trust 5 years before you apply for Medicaid to avoid the 5-year look-back period. The pros of this is that the house will have asset protection, but the cons of this are going to be that you give up control over the house that's inside that irrevocable trust because you generally cannot be the trustee or the the beneficiary of the irrevocable trust. So as an example, you would not be able to personally sell the house or take distributions from the sale of that house as an individual. The second option is going to be a life estate deed. This one allows you to keep living in the home until you pass away, and at that point it will avoid the probate process and go directly down to your heirs. The pros of this is that it's simple, it avoids probate, and it gives your property asset protection from Medicaid. The cons of this is that you have to get permission from the heirs of the life estate deed if you ever want to sell that property while you are alive. The third one is going to be a ladybird deed. It's just like the life estate deed, but with one exception. Is going to be that you maintain control instead of the heirs maintaining control over that property. You can sell, refinance, or revoke the ladybird deed while you're alive, and then when you pass away, it will avoid the probate process and go directly down to your heirs. The pros of this is that you have full control while you're alive, it avoids the probate process, and there's no 5-year look-back period being applied to this particular tool. The cons of this is that it's a new tool in the state of Georgia. It was developed in 2024, so some lenders still do not recognize it. Another option is spousal transfer, so you could just transfer the ownership of the property out of your name to your spouse. The pros of this is that it's simple, there's no penalty, and it's exempt while your spouse is alive. And then the cons of this is that if your spouse has to use Medicaid, then the property will now be exposed to the Medicaid recovery program. This one's going to be more of a quick fix than a permanent solution. So let's talk about how you put a plan in place to give your property asset protection from the Medicaid recovery program in Georgia. You want to take stock of your assets, your health, and your family situation. You'll need to pick the right strategy based on the timeline that you're up against. You'll need to hire an estate planning attorney to draft the documents to set up the You'll need to hire an estate planning attorney to draft the documents for the goals that you may have. Then you'll need to file a deed with the county recorder's office so you can transfer the property out of your name into the tool that you're going to use to give it asset protection for Medicaid. Then you can spend down the extra savings that you have on things that Medicaid does not count for things like funeral expenses or renovations for your home. And then when your assets are at the level that allow you to qualify for Medicaid, then you can apply for the Medicaid program. And then when you pass away, your family must notify the state within 10 days that you have passed away. So let's talk about a real life example and put some numbers to it so you actually understand how all of this is going to play out. So let's say you're 70 years old, you have a $300,000 house, and you have $50,000 in savings. Let's say you put your home inside of an irrevocable trust, and then you spend down the $50,000 in savings that you have on things like funeral expenses and renovations for your home. After 5 years go by, then Medicaid can start helping you pay for your care, and then when you pass away, you can distribute the property out from the trust to your beneficiaries without Medicaid being able to recover it. But if you do not plan ahead, in this particular example, Medicaid would pay for about 2 years of care, which would equal to about $263,000 of care. After you pass away, the state files a claim with your estate so that you can pay them back with the assets that you have, and then your house gets sold to cover the bill for the Medicaid recovery process, which will leave your beneficiaries with no assets because the Medicaid estate recovery process wiped out the entire inheritance that was supposed to go down to them. So let's go over some of the most common mistakes that we see families make. The first one is going to be using the wrong type of trust. From Medicaid Asset Protection Trust is going to be an irrevocable trust. If you use a revocable trust, that only avoids the probate process. It does not give your home any asset protection from the Medicaid recovery. The second one is going to be the one that we see the most often, is that people wait too long. So there's the 5-year look-back period that you will be penalized when you transfer assets during that period of time. With Medicaid planning, you have to plan ahead. If you think that you're going to need care in the next 5 or more years, it's better just go ahead and start planning ahead for that event and protecting your assets. Another big one is that when you transfer the house into an entity, you want to make sure that you're updating your insurance and your mortgage company, because your insurance will not cover a property after you've made a transfer out of your ownership, because the agreement that you have with the insurance company is that you will be the owner of that property. And then when you transfer into a trust or a life estate deed or with a ladybird deed, you are transferring the ownership out of your name into that entity, and you're breaching the agreement you have with your insurance. The same thing with your lender. You could be triggering the due on sale clause, which means they have the ability to call the remaining balance of your loan due when you transfer it into another entity. So you want to make sure you're talking to them ahead of time to see if they allow it. If they do not allow it, you need to see what you can do to make sure that you're doing things correctly. If you want help setting any of this up, click link in the bio, fill out the form, and schedule a time to talk to someone on our team.